for joining us for this webinar today. We have Kevin Pomfret, and he's the president of GeoLaw PC. He's a corporate and transactional lawyer with a significant experience counseling businesses and government agencies on privacy, licensing, and other legal and policy issues associated with the collection, use, storage, and distribution of geoinformation around the world. And he has a great knowledge of the location industry, geospatial technology, and the law gives him a unique insight into the challenges and opportunities that businesses and governments face using big data. So I'm going to turn it over to Kevin, but just so that you guys know, the webinar is being recorded and it'll be available to you guys after the webinar is concluded. And if anybody has any questions while Kevin's going through his presentation, if you guys can wait till the end, and we'll go ahead and address all questions after he's finished. So with that, Kevin, I'm going to turn it over to you.
Okay, well, Natalie, thank you, and I appreciate the opportunity to speak to you about something that I think is not that very well understood, and that's the geospatial data licenses, or sometimes they're called sharing agreements, and the impact and the important legal issues associated with that, and how companies can often, get into trouble or avoid trouble through those agreements. So I'm just going to walk you through a little bit about some of what I consider to be the main legal issues with respect to licensing of data, whether it be geospatial or other data, and then explain to you some of the different elements of a license agreement and why they're important. Just to start with, I'm sure most of you have seen a map or an image similar to the one I have here, but I think it's helpful to show that increasingly geospatial geospatial products and services are made up of data from different types of different sources and different sensors. Those sources may be government, they may be industry, increasingly it's from the crowd, and it may be a variety of different sensor types, whether it be imagery, whether it be ground-based sensors, whether it be drones in the future. And each of these are often subject to their own license or data sharing agreements, and each of them have their own restrictions and rights and responsibilities. And it's going to be more and more difficult to sort of understand what you can and can't do by aggregating the data unless you can appreciate what these licenses allow or don't allow. I think it's also important, I frequently talk to people about this and they say, well, we don't have to worry about this, we're a software company, we're a cloud provider. But I think everyone in the chain in one way, shape, or form is going to be impacted by this, because some of the data will increasingly have restrictions on what you can and can't do with it that will, may impact cloud providers, for instance, or software companies. And increasingly the law, and I'll talk about this a little bit, but with respect to privacy, increasingly the law is going to impact what people can and can't do. So I do think that everyone in the process should understand what the license agreements with respect to the data that they're touching allows and doesn't allow. And I give this example. Some of you are probably familiar with the OpenStreetMap, which is basically a crowd-based mapping system that was created in the UK, but is now a global database of geospatial information. And they were initially licensing their data by the Creative Commons share alike provision or license, and they moved recently within the past couple of years to the Open Database License, the ODBL, and that is meant to be an open license to facilitate the viral sharing of data. But actually it's proven to be confusing, particularly for people here in the United States, and it's also proven very difficult to use, partly because of the share alike provisions that we can talk about later if anyone's interested in that are a requirement of the license, but more generally just because it's a confusing license agreement that's tried to be all things to all people, and by doing that it's got a lot of provisions and things that make it difficult. So licensing is an important component for geospatial products and services. Some things to think about with respect to a license will define the rights, or should define the rights of the party, particularly the data provider, the intellectual property rights in the data. It should also set forth the use rights on how the licensee can use the data or can't use the data, what things that they can't do with it. It will of course set forth the payment terms, whether it be that cash or other consideration. It may be an in-kind exchange for other data, for instance. But I also think it's important to recognize that for a lawyer anyways, a license agreement doesn't just transfer intellectual property rights for consideration. It also includes the allocation of risk. So for instance, who is going to be responsible if the quality of the data is not suited for the particular purpose of which it's being licensed and someone gets injured? Who's to make sure that the data has been collected or is being used in compliance with applicable law? And who's responsible if there's injury to third parties? So all of those things are included in license agreements, often without you knowing it. So you need to understand that when you're looking at your business risk, when you're looking at what it is that you're selling or buying. And then you also need to recognize that if it's not in the license, then you're basically leaving it up to someone else, whether it be a judge or a jury or an arbitrator to decide if there's ever a dispute. And you'd much rather have the parties agree to it beforehand than leave it up to someone else to decide in the future. And then also identifies what law is going to apply. Increasingly, the geospatial community is an international one. Data sets are collected and used across the globe, and it's important to set forth what law applies to the particular agreement. So just a brief discussion about intellectual property rights. Often people, when they talk about data, refer to copyright. Copyright gives the copyright holder the exclusive right to reproduce, create derivative works, distribute, perform, and display the copyright material. Now, there's when the copyright was originally created, it could not have considered all the different ways that technology now allows for content to be created and distributed and published. So there is frequently disputes over what constitutes, for instance, a derivative work, or what constitutes distribution or performance. And you'll see in the future, I think, a number of court cases around that. So it's important to think about that and perhaps define it in your agreement as you negotiate agreements with people. But also even the right, whether you can copyright facts, is still subject to dispute, particularly in the United States. Copyright does not apply to facts. That's not considered to be subject to copyright. But in certain cases, a compilation of facts may be copyrightable. And there needs to be some originality as to how you place the data, how you arrange the data, what data you use, and what data you choose not to use. And as you can imagine, that is often subject to interpretation. I think it's also, when you talk about use of data, it's important, particularly with geospatial data, because the data is so versatile. It can be used for a lot of different things, that when it's collected in one way, it can often be used in some other way. And it's important, if you're a data provider in particular, to think about ways that your data might be used, because if you don't want it used in a certain way, you probably want to include that in your license agreement. The importance of doing that is, if you don't do it, you increase the risk that it may be used in a way that you don't want it used. And I think there's couple of different risks that you should consider. One is the risk of harm to yourself. Damages if you get sued, for instance, if you promise someone that gave you the data that you wouldn't use it a certain way, and then your customer uses it in that way, you may get sued. But then the harm to the other party, to your customer or to a third party, and you can consider that to be liability. And you want to consider those as you're licensing data to make sure that you're addressing those and thinking those through before you enter into any agreement. Another important consideration is, because data is so versatile, you may want to consider defining the markets that your license agreement applies to. For instance, maybe it could be used in the energy. You're allowing your licensee to use it in the energy industry, but you're not going to allow them to use it in the transportation industry because you have someone else you want to license it to. Define what products that you're giving to them, making sure that's clear. And defining the derived products, what it is that they can do with it, what products they can create. Because you may in the future want to be able to do that yourself and create an additional revenue stream. And then it's also important to think about what regions are you allowing them to use this data. Is it in the United States? Is it globally? Where there might be another customer in Europe that you might want to license the data to. As I said, it's important to think about who's going to be responsible if someone gets injured. As data is being used in more real-time critical decision-making by users who aren't necessarily familiar with the limitations of geospatial, you increase the risk of mistakes being made. And do you want that to be decided by judges or lawyers and juries who are not familiar with the technology or the limitations of data? or would you rather set that forth in your agreement in terms of if there's a problem, who's going to be responsible between the parties? An area that's getting a lot of attention in general, and I think will work their way into license agreements, is the concept of privacy with respect to geospatial data. Just last week, the White House issued a report called Big Data and Privacy, a Technological Perspective, and for the first time that I've seen, it referenced a broad range of geospatial technologies as being able to capture personal information. This includes satellite and drones in terms of sensors, but it includes LiDAR technology, infrared, electro-optical imagery, and also synthetic aperture radar. So I think it's clear that geospatial information is being caught up in the mainstream of big data and privacy, and how that's going to play out over the next couple of years is going to be difficult to determine. But if you're a company that either licenses or receives geospatial data, you want to make sure that your data provider or data user complied with all applicable laws with respect to how the data was collected or used. And that's going to be a challenge. And I use this image that's on right here to compare privacy and how quickly it's changed over the past couple of years, particularly from a location standpoint. So here we have a scene in 2008 in St. Peter's Square. It's in connection with one of the Pope at that time being elected, I believe. And then if you look at the similar picture in 2013 in the same square, you see just an abundance of cell phones, iPads, cameras, other electronic devices where people are taking pictures, tweeting their location, sharing it on Facebook, taking pictures of their friends, and all this activity about where they are and what they're doing, yet arguably they are expecting a greater degree of privacy than they did in 2008 when they weren't doing these things. And that's partly because of the media's attention to privacy issues, but it's also because there's just been a much greater increased concern about technology and the implications of how the data is being collected and used. And for me, I describe it as a location privacy paradox, because never has it been easier for us to collect, use, and share location information, but never have we been more concerned about it from a privacy standpoint. And that's a real challenge. So one of the things that's happened recently here in the United States is that the Federal Trade Commission came up with a decree, if you will, against a company that was collecting location information from consumers when they were downloaded an app, ironically or surprisingly for a flashlight app. And one of the things that they said is you were collecting their geolocation information, but you weren't getting the consumer's consent before you did so, and you need to do that. And so that's increasingly what we're seeing, is that location is being caught up, excuse me with that change, location is being caught up in some of the information that's considered personal. So if you're in this business, I think you need to be aware about the potential privacy implications and how you deal with those in your license agreement. And I think this is even going to be bigger. I frequently refer to UAVs as the elephant in the sky with respect to privacy, because they are really going to sort of change, I think, the public's perception, not only of UAVs, but also of manned aircraft and possibly even satellites, because the sensor capabilities are so great and because we're moving towards so many satellite systems being up. And I think you're going to see regulators, lawmakers, not only try to regulate the use of UAVs, but in effect, a UAV is simply a platform, right? But also the sensor and the data that they collect. And so it's important to keep that in mind, particularly in certain industry sections of this community that are using sensors to collect information, that they're applying with applicable law, and if you're a licensee of that data, that's been collected in compliance with applicable law. And it's also important to recognize that the privacy law is evolving. So just a few years ago, it was considered okay for law enforcement to use a tracking device on an automobile for a suspect as long as the information was collected in a public space, on public roads, public parking lots, and such. That's slowly changing. So in the case in 2012, the Supreme Court was asked to look at this issue, or actually relook at this issue, because there was a similar case back in the I believe it was in the 90s, late 80s and 90s. And they were asked to take a look at it again because so much information had been collected on this individual. Now, the court found that the placing of the device on the automobile without a warrant was a violation of the suspect's Fourth Amendment. But they used some archaic trespass theory of law that hadn't been used in a number of years. from a location standpoint, what and a privacy standpoint in general, it was what a majority of justices said outside of the opinion, where they seem to believe that tracking itself can violate a Fourth Amendment rights. So if you were to collect information about an individual for a long enough period of time, you'd be able to sort of figure out what it is that they were doing and who they were, and that may violate an individual's privacy. That's referred to often as a mosaic theory. And again, this only applies to the Fourth Amendment, so the government's right to collect information from its citizens, but it's more broadly applicable to people's concerns about privacy and ability to make inferences about people's habits, where they live, who they affiliate with. And then there's been increased legislation with respect to privacy as well. This is a proposed bill, the Location Privacy Protection Act of 2014, that requires a company collecting location data with 1,000 or more devices to post online the kinds of data they collect and how they use it and share it. Again, the point of this is simply being that when you're in this space, when you're collecting and using and sharing geospatial information, you want to make sure that you're collecting in a way that is appropriate under respective laws, depending on the information that you collect, and if you're licensing it for someone, that they've done the same thing, so that if you're ever challenged in court or by an individual, you at least have the recourse from a license agreement to protect yourself. And then just finally, I'm sure you've heard of sort of boilerplate in license agreements or in contracts. It's sort of the language at the end of an agreement that most people don't like to read, including the lawyers often. But I think it is important to think that it is important to recognize that there are some important sections in there. So for instance, like I've said earlier, which jurisdictions laws apply, particularly if you're dealing with someone outside your state or outside your country, making sure you know whose laws apply. Often where the proceedings will take place, it's often more favorable to have even if your law doesn't apply, or even if it doesn't say, you'd much rather have the case take, if there were to be a dispute, the case to take place in your jurisdiction, in your state courts. It's just easier and less expensive. You can hire lawyers to help you. Often people consider whether arbitration and mediation rather than go through a full court process. Do we want to have arbitration and mediation? Some will argue that's no less expensive, or in some cases no less time consuming, but others will argue that it's better and you can get a more favorable result. Force majeure is the ability to prevent, in certain instances, acts of God, for instance, of war, where you're not able to perform a particular act, to make sure that that's not a breach of the agreement. Assignment is the ability for you or your other party to transfer rights and agreement to a third party. You want to consider whether you want the right to do that if you were going to be sold, or if you might want to license or sub-license your technology. You might want to have the ability to transfer your rights to that in that agreement to someone else. But you may not want your customer to do that for certain reasons. You may not want them, for instance, to assign it to a competitor. And you need to think about insurance. If you want your other party to have the applicable insurance in the event that there's a dispute or if there are any damages, to protect you for indemnity, for instance. So that's sort of a brief summary of what I consider to be some of the important aspects of licensing in general, but in particular geospatial data licenses. And I know we have an hour. I was asked to speak for about 20 minutes, so I will open up to any questions someone may have.
And I'll go ahead and unmute everyone, so if you have any questions, you can go ahead and ask. Anyone have any questions?
Yes, actually. Can you hear me?
Yes.
Yes. So I actually have some questions regarding. Has there been any sort of decisions have any decisions been made in the courts? Have there been any rulings associated with creating derivative works from geospatial data?
There have been some cases as to I don't know of any cases that specifically refer to derivative works as such. None are coming to mind immediately. There have been some cases around maps, the making of maps. And so, for instance, if you take someone's map and then you try to create another map from it, what constitutes, if a map is subject to copyright protection, which it often can be, what constitutes infringing on that copyright protection, or when you have a whole new product that's not subject to that copyright. That's the closest that I've seen to a series of cases on that. There may have been, and probably have been, sort of smaller court cases, and by smaller I mean sort of maybe state level court cases that have addressed this, but none come to mind off the top of my head. Part of the problem, as you can imagine, is that it's very fact specific. Courts will look very closely at the particular data set that was the product was generated from, and then they'll look at the new product and to see if it's a derived work. And so there's not much you can do with respect to certain rules to follow, for instance.
Okay, because the reason I ask is I deal mainly in the software industry, and when you start getting into things like the GPL, LGPL, and when you start talking about derivative works, I'm trying to think, okay, well, how does the decisions and the huge gray area associated with what defines a derivative work, how that impacts the geospatial data? Like, for example, are there standard geospatial licenses that are actually used out there, or are those all mostly just on an industry basis, or an individual company's basis?
I would say right now there's still a preponderance of individual licenses that each company uses. There has been a push to create open data licenses, if you will. Some people have used the Creative Commons by CCSA or the suite of Creative Commons licenses. I don't think that they're particularly useful for data. Others have tried to use the ODBL, Open Database License. I find that very difficult to work with. I know there have been some governments. And the U.S. government I know is moving towards open data, and I know there's some talk about that. Although a lot of the federal government data is public domain data, so they don't really need to have a license to do that. To issue it. So the short answer is no. There's no one standard license that's out there that you can point to and say this is what a majority of the organizations are using.
Okay, because I guess you kind of touched on one thing that I'm curious about. You mentioned data that's actually available from the government. For example, we're considering licensing some data from the Naval Research Lab, and I'm not exactly sure what sort of license they use, or if there's anything that we should really take into consideration if we license this data that you are aware of. Because since it's coming from the Navy, it's not necessarily government, it's more military, therefore it's not necessarily subject to public domain classification. So are you aware of any pitfalls associated with licensing military data?
Is it classified?
Oh, no, not at all.
Is it their data, or is it data that they've gotten from third parties and repackaged and processed?
Oh no, the government institutions are the first party sources.
Okay.
I just didn't know if there's anything off the top of your head. If not, that's completely understandable.
Yeah, no, I'm trying to think of I can't think of anything that would be unique to military data. I mean, I guess it might depend on the type of data sets that it was, and then might also depend on how you planned on using it to see that whether it's suitable for your particular use. But I can't think of anything in particular that I would be worried about more with respect to this data than in another government agency's data.
Okay, cool. All right, well, I think that does it for my questions personally.
right, anyone else? All right, well, Kevin, we thank you so much for joining us and providing all this information. And I hope everyone jots down his information if you'd like to contact him with maybe some, side questions or maybe just to talk about a different law. I'm sure that Kevin is more than happy to talk to you outside of this webinar. So thank you so much, Kevin. And again, I'll be sending over the recorded webinar to all of you as soon as I have it processed.
All right. Thanks, everyone.
All right. Thank you. Y'all have a good one.